Okay, so here in just one moment, we will be providing service on behalf of the Mott family here at the Supreme Court of the state of Ohio. When a state chooses to enact its own alternative legislation substituted for the provisions and guarantees of the United States Constitution, that would be an unlawful act. When it directs its agents to enforce the inferior state law in violation of the United States Constitution, that is a crime called deprivation of rights under color of law. Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. So then when the prosecuting attorney uses the incorrect charging instrument, relying upon the inferior state law to deprive a person of right guaranteed by the Constitution, commits that crime, and then hands that incorrect charging instrument off to the judicial officer and asks the officer to hold the person over for the infamous crime without having the proper charging instrument in place, that judge has the duty and responsibility to ensure the power he exercises is consistent with his authority. If he chooses to exercise power based upon someone else's abuse of power, that would be a crime, and he would then be establishing a criminal conspiracy by and between himself and the prosecuting attorney. When that judicial officer then hands that order for arrest off to an officer and asks the officer to go out and perform the arrest, that officer also has a duty and responsibility to ensure that the power he exercises is consistent with his authority. If he chooses to exercise his power based upon someone else's abuse of power, then the power he exercises is no power at all, and he is then implicated in the criminal conspiracy due to his negligence. And then when he goes and performs the arrest without having the proper documentation in place, now the crime of kidnapping has occurred, and it is a federal offense because the individual is being held over for ransom in the form of bail, and therefore it is Title 18, subsection 1201. So we're going to provide this criminal affidavit on behalf of the Mott family and the other hundreds of thousands of litigants who have been charged with or convicted of a crime by the state of Ohio improperly and unconstitutionally in violation of the procedures and processes codified in the Constitution for the United States of America. Let's go do this. Hi, how are you? Good, good. Are you a clerk, court?
I'm with deputies.
Okay, awesome. Okay. So we have ongoing federal litigation that we're getting ready to argue to the United States Supreme Court. We need to make sure that the state of Ohio has been notified. Hopefully we can get the issue resolved before we go into any further litigation. The case is against the state of Washington. This is simply an affidavit. It's a notice that's being provided to the Supreme Court on behalf of affected litigants here within the state of Ohio. Again, we're hoping that we can get this issue resolved. So the certificate of service on the front, providing indication and direction on how to proceed with it. My contact information is right here. I don't provide any cards. And then the affidavit is right here. This is on behalf of this particular litigant. However, we have hundreds of thousands of litigants that are affected here within the state of Ohio. So this is the notice.
Well, in order to file a case...
We're not filing a case. This is not a case. We don't want a case within the state of Ohio because we already have a federal case. We need to join the state of Ohio in it, and the way that we do that is by bringing notice to the top judicial officer within the state, notifying them of the existence of the criminal conspiracy that exists by and between agents of the state, particularly agents of their own department. So right here, all of the information is very, very self-explanatory. It's all contained within it. It's only 2 pages long, but this needs to be provided to the judicial officers. You identified yourself as an agent of the court,
and so the court only looks at documents that are filed. In order to file something, it has to be part of a Supreme Court Ohio case.
So unfortunately, notice to agent is notice principal. You identified yourself as an agent. I'm simply the service provider. I'm providing service on behalf of the affected litigants.
I identify myself as an agent in the context that you...
Well, it doesn't matter. You identified your... Okay.
I'm a deputy clerk.
Yeah, and I appreciate that.
I don't recognize this document, and I don't understand what it is.
Okay. So the instructions are all here. It's all self-explanatory.
But I don't... It's outside my experience.
Okay. That's fine. The instructions are here and they're self-explanatory. This needs to be provided to your principal. That's all it needs to be. So thank you so much. Yeah. It doesn't need to be filed. It doesn't need to be filed. This is... Well, then that would be a decision that the state would need to make, and unfortunately, that's outside of my area, right? I'm providing service so that the principal can be notified. Principal has been notified as notice to agent, as notice principal. So thank you so much. Okay. Okay. Well, God bless. Thank you so much. Joel, I appreciate it so much. Thank you so much. Service been provided on behalf of the Mott family, State of Ohio, Supreme Court, here at the clerk's office. Thank you so much. Provided by Drop Service on the clerk, Deputy Clerk Joanne Joellen. Service has been provided on the State of Ohio clerk's office by Drop Service. Lady did not receive it. She did not take it into her hands. However, I did explain she did identify herself as an agent of the court clerk. She's a deputy clerk. Name is Joellen. So service was provided at 15:36 p.m. Eastern Standard Time. Thank you so much. God bless. Moments ago, we provided service on behalf of the Mott family here at the State of Ohio Supreme Court. When a state chooses to enact its own alternative legislation and then substitutes it for the provisions and guarantees of the United States Constitution, that would be an unconstitutional act. States may not enact their own alternative legislation and substitute them for the provisions and guarantees of the Constitution, because the Constitution for the United States of America is the supreme law of the land. So when a state does such an act and then directs its agents to act to enforce the inferior state law, that would be a crime called deprivation of rights under color of law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives the person of rights secured by the Constitution, commits that crime. That crime is a per se crime, meaning that we don't have to prove that they intended to breach their obligation. Simply by virtue of the breach, all elements of crime have been met because their willfulness and their knowledge derives from the promise they made upon entering into their office when they took an oath to support and defend the Constitution for the United States of America. So we challenge the Supreme Court as of this moment to discharge the duties of your office, enforce the laws of the United States, fulfill the promise that you made to the people of the state of Ohio, and hold criminals accountable for the crimes that they commit. We don't care who they are, what title they hold, or what office they fill. Criminals must be held criminally liable for the crimes they commit. And if you choose to do nothing, if you choose to remain negligent in this, then you yourselves will become complicit in the criminal conspiracy due to your negligence. Because any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as defendants in the action. Upon having provided notification to your agent, the clerk of court here at the Supreme Court, you have been notified. And as a result, we challenge you to take action and do your job, fulfill the obligations and promise that you made to the people of the state of Ohio, and hold criminals accountable for the crimes that they commit. You have 10 days that we're going to give you for a cure. If you choose to do nothing within those 10 days, then you will be added as defendants in the action with the United States Supreme Court, and you will be held criminally liable for the treasonous acts that you've committed against the people of the United States in refusing to follow and enforce the body of laws that govern this nation. When you take an oath and you swear that you will support and defend the Constitution of the United States, refusal to enforce or recognize the body of laws that govern this nation is an act of treason, and we will hold you liable in the same manner as any other active traitor to this nation. So we challenge you, please do your duty, step up, discharge the duties of your office, and hold criminals accountable for crimes they've committed. Thank you so much. God bless.